Some evaluation points on duress by threats. Duress can be viewed through the concept of confession and avoidance. The defendant confesses that they have the actus reus and mens rea of the offence, but seeks to avoid criminal liability by pleading duress. The minority of judges in the case of Gotts 1992 felt that the defence should be available for all offences, including murder and attempted murder. The Law Commission has been looking at reform of duress since 1974. Law Commission Report number 218, Legislating the Criminal Code, Offences Against the Person and General Principles 1993, suggested that duress should be available for all crimes, including murder and attempted murder, but they also suggest that the burden of proof should be on the defendant, such as with insanity. The Law Commission felt that the restrictive test laid down by Graham was not consistent with other defences. They proposed that all of the defendant's characteristics should be taken into account, but the defence would not be available to someone who knowingly and without reasonable excuse exposed himself to the risk of a threat, as is the position within the common law. The Law Commission's view is in conflict with the majority views of the court in the cases of the Crown against Howe and the Crown against Gotts. Some problems with allowing the defence of duress to murder. People who intentionally kill would be entitled to a complete acquittal. What about distress caused to the victim's family? A jury, persuaded of this fact, may be more inclined to find the defendant guilty of murder, after which they would be sentenced to life imprisonment. Those who may have taken the heroic route may instead choose the easier option. Lord Hailsham, speaking in the Crown against Howe, could not regard a law as either just or humane, which withdraws the protection of the criminal law from the innocent victim, casts the cloak of protection on the cowards and the poltroon in the name of a concession to human frailty, in his words. Also, one who takes the life of an innocent cannot claim he is choosing the lesser of two evils, according to Lord Hailsham. What if the defendant is told to kill the victim, and that if he doesn't, a bomb will explode and take out a packed airliner? Isn't this the lesser of two evils? Situations where the defendant's family are threatened with death if they do not kill another are relatively common. See Abbott v. the Queen, 1977. In difficult cases, the Crown Prosecution Service could always decline to prosecute due to it not being in the public interest to do so. But why should the freedom of a morally innocent person be subject to a purely administrative decision? Recognising the defence for murder would lead to overriding Dudley and Stevens. The statement of Lord Hailsham regarding heroism is also not without criticism. But should we have to be? As Reid and Fitzpatrick have pointed out, Lord Hailsham's statement effectively requires that the defendant lives up to the standard of the reasonable hero, rather than the reasonable man. There is no duty of heroism within the law. Joshua Dressler, one of the United States' leading experts on criminal law and procedure, had the following to say about the statement of Lord Hailsham. I am afraid that such a rule, like Lord Hailsham's opinion, has the imprint of self-righteousness, which the law should avoid. The rule asks us to be virtuous. More accurately, demands our virtual saintliness, which the law has no right to require. It is precisely in the case of kill or be killed threats that the criminal law ought to be prepared in some cases to assuage the guilt feelings of the homicidal wrongdoer by excusing him, by reminding him that he acted no less valiantly than any person of reasonable moral strength would have done. However, in the case of Howe, Lord Lane in the Court of Appeal, Lords Bridge and Griffiths in the House of Lords urged caution against extending the defence to murder. They felt that allowing the defence to extend to murder could be a highly dangerous relaxation in the law, allowing a person who has deliberately killed maybe a number of innocent people to escape conviction and punishment altogether because of a fear that his own life or those of his family might be in danger if he did not. Lord Lane also stated that the defence of duress was so easy to raise and may be so difficult for the prosecution to disprove beyond a reasonable doubt. Lord Hailsham himself even admitted in the case of Howe, page 434, that juries have been effective at rejecting the defence in undeserving cases. Now it's time for Rory Mayo's top tips.
Rory Mayo's top tips. In the case of Graham, 1982, the Court of Appeal laid out the requirements for the defence. These requirements were later confirmed by the House of Lords in Howe, 1986. The requirements are subjective, the defendant must be overwhelmed by threats, and objective, a sober person of reasonable firmness would have been compelled to offend.
All we can